You ever wonder when this country stopped being ruled by the people and started being ruled about the people? We pledge allegiance to a republic, not a monarchy. Yet every law, every right, every freedom is now filtered to the opinions of 9 unelected lawyers in robes. This episode isn't about politics. It's about theft, the slow, quiet theft of authority. Because the Constitution never said judges get to decide what freedom means. They took that power, and we let them. Welcome to Constitutional Outlaw. This is Episode 1. When review became rule, the origin of judicial power. The year is 1803. America is young, rough around the edges, but free. The Constitution is only 16 years old. The founders designed 3 branches. Legislative makes the law, executive enforces it, judiciary interprets it in cases. That last part matters. In cases, not in theory, not in ideology, not as a throne of truth. Then came Marbury v. Madison, a simple dispute over a commission, a paperwork fight, turned into the biggest power grab in our nation's history. Chief Justice John Marshall didn't just rule on a case. He rewrote the rules of government. He said, "It is emphatically the province and duty of the judicial department to say what the law is." Sounds harmless, right? Except that sentence flipped the entire system. That's the moment courts became kings. No vote, no amendment, no consent, just one decision. From then on, the court didn't just interpret the law. It defined the law. Thomas Jefferson called it what it was: despotism of an oligarchy. He warned that giving judges final say meant the Constitution becomes a mere thing of wax in the hands of the judiciary, which they may twist and shape as they please. And guess what? That's exactly what happened. The early expansion, from guardians to gatekeepers. The founders built walls to contain power. But once Marshall cracked that foundation, every generation of judges built on the crack. By the mid-1800s, courts weren't just interpreting. They were legislating. They used substantive due process, a phrase that never existed in 1787, to decide not whether laws followed procedure, but whether they felt right to the judges themselves. Then came the Lochner era. The court struck down labor laws meant to protect workers, claiming they violated a freedom of contract. Imagine that the same Constitution that guaranteed liberty was weaponized to keep poor people chained to 14-hour workdays. And they called that justice. Each ruling carved a little more out of the people's sovereignty. The legislative branch, your representatives, became subjects to the judicial veto. The judiciary, meant to be the weakest branch, became the most dangerous. The 20th century, the language of power. Fast forward to 1938, United States v. Caroline Products. Footnote 4, a few lines buried in a milk case, birthed the modern religion of judicial scrutiny. Strict scrutiny, intermediate scrutiny, rational basis. Sounds technical, but it's nothing more than a sliding scale of obedience to the state. Strict scrutiny. They say that's when government must prove a law is necessary to achieve a compelling interest. But who defined compelling? They do. Intermediate scrutiny, where the government's goals are just important enough to limit your freedom. By whose standard? Theirs. And rational basis, the lowest of them all, where government wins as long as a judge can imagine a reason for the law. They can literally invent a justification after the fact. Let that sink in. If the state can hypothesize a reason, your rights can vanish. They call that law. I call that legalized imagination. The founders called rights unalienable. The courts turned them into negotiable. The public interest fraud. Then came the magic phrase, public interest. Used everywhere. Means nothing. It's the all-access pass for government intrusion. They say your freedom must yield when it conflicts with the public good. But who defines the public good? The same people whose power depends on limiting yours. The Constitution begins with we the people, not we the government. The purpose of government was to serve the public interest by protecting rights, not by restricting them. Every law should begin and end there. Instead, judges began saying, we must balance the individual's rights against society's needs. But society has no rights. Only individuals do. Balancing freedom is a vocabulary of tyranny. And every time the court used those words, your liberty tilted a little further toward government convenience. How it grew, rights on trial. Once balancing tests became accepted, judges created a library of tests and standards. Anderson verdict test weighs the burden of voting laws against the state's interest. Translation: if it's too hard to vote but the state says it's important, you lose. Chevron deference: courts defer to agencies' interpretations of law. Translation: let the bureaucrats decide. Compelling interest tests: government claims anything it wants as compelling. Translation: you don't need rights if we say it's for safety. They invented these doctrines out of thin air and used them to bless nearly every expansion of power since. Surveillance, wartime detention, emergency powers, censorship, vaccine mandates, all justified by judicial invention. The modern crown, judicial supremacy. By the late 20th century, presidents rule by executive order and agencies rule by regulation, but only because the courts let them. Judicial review had become judicial permission. No longer is this constitutional. Now it's, can we rationalize it? Think about how far we've fallen. The framers risked everything to escape kings. Today, we've crowned new ones, courts that cannot be overruled. When judges treat the Constitution as a suggestion, government becomes its own referee. You don't need to break the law to lose your rights anymore. You just need the government to find them inconvenient. The people's responsibility. Here's the hard truth. The reason this happened isn't just the court's arrogance. It's our ignorance. We stopped reading the document that created this nation. We started worshiping the people who interpret it. And as the saying goes, if you don't know your rights, you don't have any. That's not just a slogan. That's reality. A right unclaimed is a right erased. And if we don't fight to reclaim constitutional meaning, the next generation won't even know what freedom felt like. Our founders didn't write the Bill of Rights for lawyers. They wrote it for you, to limit them. Every test, every standard, every scrutiny level is a mask for the same truth. Power protects itself. The call to the movement. So what do? We stop treating the courts as gods. We remember that the Constitution is not a living document. It's a binding contract. And contracts mean nothing if one side gets to reinterpret them at will. Judges were meant to guard liberty, not grade it. And it's time the people remind them who they serve. We study, we speak, we share, we teach others to recognize the game. The way every test is just another excuse to make the government's job easier and your life smaller. That's the mission of constitutional outlaw. Because justice doesn't plead bargain, and neither should you.